For example, the Supreme Court has issued numerous politically determinative decisions, nearly all of which promote a trajectory of expanded federal power, including the court's own authority, in defiance of the Constitution's structure and limits. On such occasions, the justices contort the facts and law, as they must, to reach their desired result. For example, in the 1942 decision Wickard v. Filburn, the court ruled the Interstate Commerce Clause encompasses commerce that is intrastate, and therefore the federal government has the power to regulate endless forms of private economic activity, including the production of goods and services for one's own use or within a state. In the 1947 decision, Everson v. Board of Education, the court declared the long-standing balance between government and religion void, and the extension of a wall of separation between church and state, leading to the banning of prayer, nativity scenes, crosses, etc., among other forms of religious expression, in the public square in states and localities across the nation. That phrase comes from a letter that was written by Jefferson to the Danbury Baptists and has nothing to do with the Constitution, and Jefferson himself was never at the Constitutional Convention. In the 1965 case Greenwald v. Connecticut, the court found that the penumbras and emanations in the Constitution prohibited states from banning the sale of contraceptives, a ban that was rarely enforced. What are penumbras and emanations? Well, nobody knows. In its 1982 decision in Plyler v. Doe, the court conferred a constitutional right on millions of illegal alien children to a free public education. In the 2003 Lawrence v. Texas case, the court ruled that sodomy is a constitutionally protected privacy right. Such laws, by the way, were already being repealed by most states throughout the nation. But it laid the groundwork for a future court ruling that same-sex marriage is a constitutionally protected right. And the 2012 Obamacare decision, in which the court ruled that a penalty is a tax, contrary to the statute's text, legislative history, and the court's precedent, and of course the Constitution's text, and therefore the federal government, it ruled, has the power to force individuals to purchase government-designed private health insurance policies. Now, there are many more examples. Some cheer these decisions, some denounce them. But should 5 individuals be making these political and public policy decisions and imposing them on every corner of the nation and every part of society? Should they have the final say on such matters as they pursue even newer and more novel paths around the Constitution in exercising judicial review? It's important to recognize that the Supreme Court's record at times is grievous. In addition to the Dred Scott decision, in which the court perverted the Constitution to promote slavery, other notable examples include the 1896 Plessy v. Ferguson holding, where the court sanctioned racial segregation in public facilities under the doctrine of separate but equal. The 1944 Korematsu v. United States decision, where the court gave license to the Army's internment of tens of thousands of Japanese Americans without due process. And the Roe v. Wade decision, the 1973 ruling in which the court legalized abortion throughout the nation without any legitimate constitutional basis whatsoever. Barely 100 justices have served on the Supreme Court. As few as 5 justices can dictate economic, cultural, criminal, and security policy for the nation. 1 new justice replacing a retiring or deceased justice can sway the court in one direction or the other. So the political battles for control of the court when vacancies occur. It is truly absurd that so many defend the evolutionary role of the modern court as supreme to all other institutions of government and insist on the finality of its rulings. The biggest myth about judges is that they're somehow imbued with greater insight, wisdom, and vision than the rest of us. That for some reason God Almighty has endowed them with superior judgment about justice and fairness. But the truth is that judges are men and women with human imperfections and frailties. Some have been brilliant, principled, and moral. Others have been mentally impaired, venal, and even racist. Consider a few of the stunning personalities who've served on the court, who you would categorize in the latter group. John Rutledge, a 1795 recess appointment as the nation's second Chief Justice, was considered mentally unstable. Henry Broadholst Livingston, appointed in 1806, killed a man in a duel before his appointment. Henry Baldwin, appointed in 1830, was reportedly insane. Robert C. Grier, appointed in 1846, became mentally incapacitated, yet continued his duties on the court. Nathan Clifford, appointed in 1858, suffered a stroke and became a, quote, babbling idiot, unquote. Stephen J. Field, appointed in 1863, gradually lost his mind. Joseph McKenna, appointed in 1897, became mentally unstable and resisted retirement. James C. McReynolds, appointed in 1914 by, I might add, Woodrow Wilson, was a notorious anti-Semite and racist. Hugo Black, appointed in 1937 by Franklin Roosevelt, I might add, had been a member of the Ku Klux Klan and remained on the court despite his declining mental health. William O. Douglas, appointed in 1939, allegedly sexually assaulted a flight attendant in his chambers and remained on the court despite suffering an incapacitating stroke. Abe Fortas, appointed in 1965, continued to advise Lyndon Johnson after his appointment and supplemented his court salary from a foundation set up by a convicted stock swindler and was eventually forced to resign. Thurgood Marshall, appointed in 1967, in his waning years, apparently spent many hours watching television in his chambers, especially soap operas. Now, the mechanisms the framers put into operation relating to the judiciary were designed to achieve certain vital purposes that would in turn help ensure the successful operation of the national government they established. They knew the sordid history of monarchs and bureaucracies compromising jurisprudence to serve political ambitions. And they didn't want that to happen in the United States. They sought the independence of the judiciary to help establish and preserve the integrity of the federal judicial system and by extension the national government itself. And they read John Locke, and they read Charles de Montesquieu, and they understood the importance of three branches and an independent judiciary. They included mechanisms to evaluate nominees for the federal judiciary, the presidential nomination and senatorial confirmation process, as well as hold justices and judges accountable for their misdeeds, as I said earlier, the impeachment process. Now, there have been many great justices and many great rulings, but the Supreme Court exercises today power that really the framers never intended. It's not sanctioned in the Constitution. It's not consonant with Republican government. And impeachment is, as I said, a dead letter. But it is clear that the notion of judicial review has long been acquiesced to and is now ingrained in such a way as to make its uprooting imprudent, if not impossible. That said, there is no reason a great society must surrender for all time and in all cases to a judicial oligopoly exercising supreme power over the other federal branches and the states. The Supreme Court should be independent, but it should not necessarily be supreme, leaving society without recourse. So I proposed in my book, Men in Black, term limits for Supreme Court justices. While I don't think that will even be enough to return the court to its proper foundational role, and I have other ideas I will present in the days ahead, I believe ending the lifetime sinecure of justices and replacing it with a single 12-year term of office with no possibility of renomination or a second term serves the purpose of preserving the independence of the justices as they make their rulings, yet ensures that no single justice can have an inordinate influence on society, far exceeding any rational structure within a Republican government. After all, these are, as I said, imperfect human beings who, as a class, have become increasingly political as they impose their personal policy preferences on the rest of society. James Madison and his fellow convention delegates wisely settled on an independent judiciary, but they were troubled about the prospect of a supreme judiciary. Madison wrote, quote, "As the courts are generally the last in making the decision, it results to them, by refusing or not refusing to execute a law, to stamp it with its final character. This makes the Judiciary Department paramount, in fact, to the legislature, which was never intended and can never be proper." So you might ask, well, Mark, what is the right approach to interpreting the Constitution? As I explained in my book, Liberty and Tyranny, language consists of words. Words have ordinary and common meanings. and those meanings are communicated to others through the written and spoken word. When parties enter into voluntary arrangements, such as contracts, they use words to describe the terms and conditions by which they are obligated to perform and on which they are expected to rely. Contracts are interpreted and the intention of the parties discerned in the context of their original meaning. That is what is meant by originalism. The Constitution is, in essence, a social contract. It sets forth certain terms and conditions for governing that hold the same meaning today as they did yesterday and should tomorrow. It connects one generation to the next by restraining the present generation from social experimentation and government excess. There really is no other legitimate standard by which the Constitution can be interpreted without abandoning its underlying principles altogether. If the Constitution's meaning can be erased or rewritten and the framers' intentions ignored, it ceases to be a Constitution, but is instead a concoction of political expedients that serve the contemporary policy agendas of the few who are entrusted with public authority to preserve it. This phrase, living and breathing Constitution, suggests that the Constitution must change with the times, that it must conform to modern culture, and so forth. This notion conflates the civil society with government. It is the civil society, that is, the community at large, where individuals are free to pursue their interests and grow and evolve in unanticipated and unpredictable ways, where there's living and breathing. But the purpose of the Constitution is to preserve the civil society, not devour it, and thereby devour the citizenry. Now, the problem with a living and breathing Constitution is that it becomes increasingly authoritarian, supporting behavior by a smaller and smaller circle of masterminds exercising their expanding power. Then you might ask, well, what is my approach to judicial review? I think it's fair to say that the elected branches of the federal government have essentially acquiesced to the notion of judicial review, where the Supreme Court has the final say on what is or is not constitutional. I don't agree with this, and as I said earlier, I will make the case for a proposal in ensuing months to address this. That said, originalists believe that the powers enumerated specifically in the Constitution are the only powers of the federal government, unless the Constitution is formally amended. Originalists generally interpret provisions of the Constitution and, when applicable, statutes narrowly. In other words, these judges attempt to look at the plain meaning of the law. They believe in a clearly delineated separation of powers. But a judicial activist, on the other hand, construes the Constitution broadly and rejects some of its provisions outright or gives them superficial acknowledgement if they interfere with the desired outcome. In essence, then, activist judges make rather than interpret the law. When the judiciary utilizes outcome-determinative reasoning rather than adhering to the Constitution, the result can be catastrophic, as I detailed earlier. Now, although this is the end of my lecture, I hope it's the beginning for you of an understanding of the Constitution and the courts. And there's so much more to learn and so much more to understand. And I hope I've instilled in you a spirit to go out there and grab it. Thank you very much.